What's up, viewers, subscribers, and agents alike? This your boy Enlightened Luciferian Prince coming at y'all once again. Welcome. Thank y'all for viewing my channel. Thank y'all for viewing my content. And we proceed. If it's your first time viewing this channel, please like and subscribe. Please, because if you don't, you'll be missing out. Also to mention, if you're watching this video around children, this does not constitute legal advice. The sole purpose of this information on this channel is for informational and educational purposes only. There we go. Now that we got that out the way. Now, the title of this video is called By Whose Authority? Okay? I want you to understand for the simple facts of the matter. And again, for those who are inept of hearing what I had to say in the disclaimer, this does not constitute legal advice. The sole purpose is for informational and educational purposes only. Now, if you are in a legal situation that involves a person or their property, a live natural person, please consult an attorney if you don't know what to do. This is not a channel that is instituted as legal advice. Now, by whose authority? The reason why I want people to understand this is because going back to my previous video, I think somebody particularly asked, well, did you have any remedy by this? And of course, I'm an individual who leads by example. So I tell people, stay tuned. I say that for a reason. Because one of two things is I can say anything online to convince a person, may they believe it. But I'd rather let my actions speak louder than any of words that could amount to any type of conclusion. I'll just let the evidence speak for itself. That's the best way for any truth to be solidified in the face of those who doubt or in the face of those who just don't have the wherewithal to apply the things I talk about. So I use myself on my channel and my platform as an example to otherwise dispel the madness that is around these subjects that a lot of people talk about, but otherwise don't practice. Names aside. But by whose authority? Whenever you're dealing with a court matter, for any in all intents and purposes, after 1938, Erie Railroad versus Tompkins set the strata for the court system in the United States. Any Supreme Court decision prior to 1938, in and of itself, is what we call common law. After that, it became admiralty, maritime, and civil, all combined into one court. Because it's all about contracts and the governance thereof. Now, the reason why I say by whose authority is because upon early in this journey, I knew a lot of people. They were heavy on the oath of office, judges swearing the oath of office, and so forth and so on. Sounds nice until you really get down to the heart and the meat of the matter. Now that we are past that oath of office subject, we know that they are perfunctory because if it indeed does not say in their oath of office expressly the Constitution for the United States that they swear the oath to, then your whole presumption on the fact that them bringing that forward to prove their authority is faulty at best. That does not prove their authority. That does not prove that these individuals are actually qualified to be judges. Because remember, when you're dealing in commerce, you are not dealing with the judiciary as you know it. You are dealing with the judiciary, and the simple fact of the matter is that they're going to play a lot of word fraud with you. And the words that you think in legalese are not the same as they are in standardized common man English. As dog of a language as English is, it still has a very much significant grip on the vernacular and how we use it in the westernized society from English law, which has in and of itself been impregnated with vulgar Latin, pig Latin, and also to mention a little bit of Judaism. Now, I know this may raise controversy for many people who have not done their studies in the legal realm, but if you read the Shatar, then you'd understand exactly what I'm saying is very true. But I know that a lot of people haven't read this stuff, So let me basically break this down in the simplest terms that I can. The shatar in and of itself was nothing more than a lien, the Jewish gauge, quote unquote, which in law has enacted itself to coincide with positive canon law and therefore has transmorphed into what we call common law in English. Now, since we know common law has not been, nor ever will it ever be understood upon the multitude of people in the masses, there had to be a way for it to be transcribed to the masses with something being done on the commercial side, with the otherwise common man side of it still flowing functionally with the direct executing of depriving one of property while enriching the other, i.e., robbing the trust as the beneficiary. And this is what the state does. Now, the reason why they have the ability to do this is because the simple fact of the matter is that you, the common man or woman, still hold yourself in position to believe that you are obligated to that instrument. Although it may be a simple claim, the agenda it still remains the same. Now, this is in accordance to a very simple matter, i.e., a victimless crime. A victimless crime, in and of itself, is a misnomer because for it to be a crime, it results in a victim. However, most people are unaware that simple things such as traffic citations and tickets always wind up in the criminal venue. I just previously explained that to you and showed you in a previous video where I was on the phone with the Superior Court clerk. In and of itself, that in and of itself is enough to say that there's fraud upon the court. Why? Because it's in criminal jurisdiction. 2, there is no injured party. So why is it in the wrong venue? I'll tell you why. Because it's a claim, nonetheless operating under the guise of admiralty maritime law, although it is still the enforcement of a contract, which is where UCC comes into play. Now, I tell people all the time in this respective realm, if indeed you are not a secure party creditor, or you are not seasoned, or you are not studied well enough in these topics, I suggest you do not try anything until you are fully equipped on knowing what you're doing and why you're doing it in the first place. Because of many people's error in being competent in regards to a lot of this stuff that I'm basically saying and been saying for years, it brings ill repute on the community of anyone who wishes to actually resolve their commercial matters in a peaceful manner. For the simple fact of the matter is that most people are not aware that you must be competent when it comes down to these processes. Because I tell you, and this is a word of caution, you go in there in those environments playing around, you will be dealt with. The object is that I've been saying on my channel for a long time, settle with your adversary before you get to court. There's a reason why it says that in scripture. There's a reason. Because if you have the remedy, then your job is to actually let your adversary know this is going to be a waste of time. Not only is it going to be a waste of time for me, I get paid for it once it's dismissed because I can get my recoupment for damages for basically a false claim. So I suggest you might want to read over those documents that I sent you prior to us going to court. And then maybe we can talk about a dismissal. But I'm not here to accept any liability on behalf of an ens legis fiction. This is what you tell the prosecution when you're in the right, prior to you going to court. The prosecution has 1 or 2 things they can do. They can deny it, act like you never said anything to them, and simply just go on to court and be dismissive of what you're saying. But now here comes the flip side of it. You have to defend it now because they want to see as far as you're really willing to go. Because remember, the adversary really wants to see as far as you can go. But here's something simple that a lot of people don't understand. In order for a judge to rule over this case, they must have express permission from the trustee, in and of itself, being the Secretary of the Treasury of Puerto Rico. They must have a signed delegation of authority to access your trust or to settle the matter on behalf of the beneficiary, which is the trust. But then they're going to usurp the position of beneficiary and make themselves the beneficiary and make you the surety, which is what they do on all contracts. But I said in previous videos before, but people weren't listening. It's okay. Sometimes it takes a little bit of time for you to get used to a subject. Hey, be it as it may, it's the truth nonetheless. But for people who need reference, you can look at 26 United States Code 7603. You can look at 26 United States Code 6903 and 28 United States Code. I am so sorry, people. 28 United States Code 7603. Now, it says special procedures for third party, which is 26. I apologize. So it's 26 U.S. Code 6703. Now, it may come up as 26 United States Code 7609, special procedures for third party summonses, which coincides with 7603, 76903, 76036, which is 42 United States Code section 6306, administrative procedure and judicial review. All this is saying in but the legalistic sense. I'm just going to tell you, they have to have a signed delegation of authority from the Treasury of Puerto Rico. You know why most, if not all cases, I would say summarily all, cases in the United States are determined in this factor to basically make you the surety? It's because by your own acts and your own omissions, you're voluntarily giving up certain information to the court, and that's what they need. I tell people the reason why taxes in the courts are similar in very, very many ways is because they're voluntary. The proceedings are voluntary. When you get mailed something from the IRS, it's voluntary whether you comply with it or not. Now, here's when it becomes involuntary. When you harm a person or their property, there's nothing you can do. But here's another kicker on the lesser limb of that tree, which is basically if indeed you did not harm a person or property, it's still voluntary. Now, involuntary is when you harm a person or property, come to get you. It is what it is. No remedy for you. Now, when it's victimless, it's still voluntary in the sense. It's like, hey, now you can agree to contract. You could agree to submit it to them, let them argue it out and get your remedy. You can reject the contract. They still may compel performance, or they turn around and particularly go all the way, which is where I left off in the last instance. You, as the secure party creditor, as the individual who has all of his ducks in a row, I'm not saying bombard the courts with paperwork. Fuck no. It's not for the courts to even see. It's only between you and your adversary. Now, if you feel as if you want to copy claim it to the court, by all means. But this is the reason why I said on my last video, when it said particularly a court of record. See, when you were talking about a court of record, now you have their attention. See, all you people that goes into those venues and think that this is due process, it's not. You can forget about that. Forget about that shit 1000. It's never due process. It's only the process due to get the contract moving. That's all it is, people. But a court of record is due process. And it's your right to enforce that. If you don't, they're going to proceed as if they always had. Run of the mill. Next contract. Run of the mill. Next contract. Run of the mill. Next contract. Until 5 o'clock every day. Monday to Friday. But just don't let your case be that determined factor of guilty. But anyway, once you state on record, number one, does the judge actually have a Form 56 on file to act as a fiduciary on behalf of the Treasurer of Puerto Rico? The answer is clearly going to be a fucking no. No, they don't. Your job, for all you Form 56ers out there who finally have understood what I've been saying for years, it is your responsibility to have that provided for them, but you are the individual who is acting as the fiduciary. Is it making sense now, people? That I said this well over 6 years ago? But nobody paid me attention. No. Y'all started going to all these other people. And where the fuck did that wind you up? Right back here listening to me a couple years later. Go figure. But anyway, needless to say, since you don't have that, this is your response. Since you don't have it, it's my job to place on record that I will take care of that responsibility for you as the secured party to this action. Needless to say, I doubt if the proceeding would go any further. But that's just me. Because there can be no judgment rendered when you have provided the remedy. You basically stonewalled the shit out of them and put their quote unquote dick in the dirt. Because they can't move. Because you have denied them access by being responsible for your fiduciary responsibilities. I hope this in 2025 makes a lot of fucking sense for you people, and you stop acting like a debtor. And you stop acting as if an individual owes somebody something. They're after your trust. They need it to exempt themselves from liability, and you keep giving it to them. Willingly. Would you like to also know the cherry on top? For all you people who's caught up in this citizenship shit, let's get one thing straight. Let's get one thing straight. This is the reason why they send your ass to jail after you take a plea. Think I'm lying? 18 United States Code, subsection 911. Citizen of the United States. Notice what it said, citizen. It didn't say United States citizen. It said citizen of the United States. Whoever falsely and willfully represents himself to be a citizen of the United States shall be fined under this title or imprisoned not more than 3 years or both. Wait a minute. Did you hear what this just said? 18 United States Code, subsection 911 said citizen of the United States. Now go read your 14th Amendment. You like to go argue so much. And let's look up the legal definition of the word subject. And let's put it together in your best mind, right? You will understand how this works today. You will learn. Here it is. Subject to the jurisdiction thereof is a phrase of the 14th Amendment of the United States Constitution that means being under the authority of the U.S. government, which is a corporation. It appears in the first sentence of the amendment, which establishes the principle of birthright citizenship. That's bullshit. When it says subject means underneath. That means beneath me. That means, for all the people who like to say sovereign citizen, hate to bust your bubble, you got to find a new catchphrase. You can't be both. Because the United States is saying they're sovereign over your citizenship. So let that be a motherfucking wake-up call for all you agents who like to come on here and purport that bullshit. I meant to say perpetrate, but purport is much better. Real shit. Got me tongue twisted. Y'all love saying that shit. People who read, we just know y'all bullshit. Y'all could call us whatever y'all want. We just know that y'all operate in fraud. But you only do it by our ignorance. Call us whatever you want. But don't call me no damn U.S. citizen. But that's the reason why you go to jail. Whenever you take a plea, they say, are you a U.S. citizen? Have I been guilty of it before myself? Fuck yeah, when I didn't know any better. When I didn't have a clue, I said yes. And where the fuck did I go? To jail. So with that being said, people, this is how you actually discharge victimless offenses. But this is my life. I'm not going by nobody else's explanation, nobody else's business, none of that. Hold on, this all right. You're going to open the door for you in seconds, my dog. But with that being said, they have no authority, people. Because unless you act as the fiduciary, which now you understand the importance of Form 56, and you understand how that correlates to you, then now you are the individual who is recognized as having standing in law. But if you don't have the fiduciary and secured capacity to operate in commerce, I suggest you sit the fuck down before you go in there playing with them people. Because not only that, because they know you really don't know, you might warrant some shit that you might not like on you. And this is just a word of warning. It is that simple. If indeed you go in there playing with the people where you ain't got all your ducks in a row, Godspeed. But if you are, you prepared, you have no victim, you should have no problems. Hindrance, a little bit of a delay, whatever, comes with the territory. Trust me, I did not get this overnight. It took me time. It took me way more than 21 minutes, which you just learned in less than that. It took me years. And I tell people all the time, irrespective of appearance and how people may judge me, I am a very peaceful person. I don't commit crime. I don't hang out and do all nefarious activities. I mind my business. I take care of me and my family, and I live a simple life. I'm not anti this. I'm not pro that. I'm just me. Simple as that. And I'm an individual who loves to read. Simple. By reading, you totally disarm your opponent because you have learned the reality behind ignorance of the law is no excuse. So the more knowledgeable you become in the law, you definitely don't have an excuse now, but it's a double-edged sword. Because just because you didn't know something didn't warrant a type of punishment doesn't mean you can't be held liable. That's why they try to use it in that sense. But let's use it when you have both sides of your brain working and you're saying, I know the law. As a matter of fact, I know the law that you didn't want me to know. And if I have to execute this, by all means, in case of emergency, I will break your ass. But the question is this. True power lies with restraint. In letting your adversary know, I don't want to do this. But if I have to, I will. And I will recoup all damages for all harms done. Now, if you wish to proceed with this, just know that I'm giving my consent that it's going to work out in my favor. I'm giving my consent to proceed. You do what you must. But I'm willing to go however far you're willing to go. Because I have what's one thing on my team that you don't have, which is truth. So if you wish to go to court, just know I'm going all the way. That is how you execute being a secure party creditor. Not sending thousands of papers all over the place with no. You're wasting time, energy, and stamps. Your job is to let your adversary know who you are from the initial confrontation. And there shall never be no more after that. And if they continue, let them hit the pocket. Just like Congress doing right now. All the people running around like a rat race. Because they know it's coming for them too. Oh, you will see it in 2025. But all you righteous individuals that's out there living your life and doing the right thing, stay enhanced in the power of the Most High. Because as long as you got the truth on your side, they can't do shit to you. They can call you whatever they want. They can mock you. They can deride you. They can do whatever they want. Just keep the number one element on your side and everything works out in your favor. The truth. That is it. You want to be the case in court? Tell the truth. The commercial truth. Don't ever tell any type of truth that otherwise may harm you. Especially if it's a victimless crime. Victim crime, can't do nothing with that. I don't know nothing about that. But y'all people stay amazing. If you, again, have not subscribed, please hit that notification. Please hit that bell so every time I drop some heat, you won't be left out the loop. I also leave my email information and my contact information in the video description and the comment section below. Thank y'all for tuning in. Just remember, it's all a tax matter at the end of the day. And those codes and citations I just read to you is simple proof that they agreed with the IRS to go by the code. It is your right and your responsibility to know what code that is. If you don't, just remember, ignorance of the law is no excuse. Peace, light, love. Y'all take care. Agents, fuck you. Simple as that. See y'all soon. Y'all take care.